morning to you all. Today is a very serious one. We're trying to look at the decision that was made by the Supreme Court recently on whether a presiding deputy speaker can be counted and can also vote. It's a landmark decision that was taken recently by the Supreme Court. It was a 7-0 unanimous decision, meaning that all the 7 Supreme Court judges or justices that sat on the case all decided, gave a unanimous, or they all had a particular one decision. Now, you can see in my hands the 1992 Constitution, because this is a very important discussion. I must also clearly state that per the laws of Ghana, is the Supreme Court that has the authority to interpret matters of constitution. And anytime the Supreme Court takes a decision, it's final and it's binding. The only group that can overturn the decision of the Supreme Court is another, should I say, a Supreme Court that has been formed to review the decision of the Supreme Court. So when there is a decision that is taken by another court, it can be reviewed by probably the High Court. The High Court decision can be reviewed by the Courts of Appeal. The Appeal Court's decision can be reviewed by the Supreme Court. But the Supreme Court's decision stands final unless, upon appeal, a Supreme Court constitutes another team to look at it, and upon review they could change it. But apart from that, it's binding. Now let's quickly go into the issues. We are going to discuss 3 things. The first one we are going to look at is what are the issues that were taken to the Supreme Court. I'll make it simple for us as soon as possible. Now, the second thing we also look at is what are the implications and why are these matters very, very necessary for Ghana's democracy, why the implication of these issues for Ghanaians, you and I, the implications of these issues for Parliament, the implications of these issues for the MPP and the NDC. I said the MPP and the NDC because Parliament is only made out of MPP and NDC, and the executive arm of government is also predominantly either NDC or MPP, but currently is MPP. But trust me, these matters, I'm going to discuss it dispassionately. Don't take it personal. It is good for our democracy. Like I said, the Supreme Court has the final authority. We can just express an opinion on the judgment, whether we agree or disagree in a matter of law, but you cannot show contempt to courts, especially the Supreme Court, by disrespecting or refusing to enforce or abide by the rulings of the Supreme Court, or disrespecting the rules, or should I say the courts as a whole. That would be contempt of court, and that's not what we are doing here this morning. We are just expressing our view on the matter and the judgment, and what we also think dispassionately, in the greatest of respect. Now, so the first issue is that now we all know that Ghana's parliament currently is made up of 137 members of parliament who belongs to the NPP, and 137 members of parliament that also belongs to the NDC. Then there's an independent candidate, that is the former MP. Now he has decided clearly to do business with the MPP. So the MPP, in addition to the former MP, who is an independent candidate by a former MPP member or an MP, becomes 137, giving them a slim majority. So that this is the back and forth. Now there were 3 issues that were taken to Parliament, to the Supreme Court to be decided. Now the Constitution clearly states that the Constitution shall be the Supreme Court of the land in Article 1 clearly, and it also says in Article 1(2) that any law that is found to be inconsistent with the Constitution, to the level of inconsistency, is null and void. So let's be clear on that. Now, by saying that, to Section 1(1) also tells us that the supremacy of, should I say, Ghana shall reside in the people, on whose behalf the laws are supposed to be exercised in their warfare. So that's it. There is also the freedom of the media that has been clearly stated, but it has limits and all that. Now, there were 3 matters that were taken to court. Now, the first issue was that upon proper and true interpretation of Article 102 and 104, whether or not the deputy speaker, when presiding, can be counted in order to form quorum. And 2, whether or not the deputy speaker, when presiding, can also cast a vote. Then the third one was that whether the decision taken to approve the budget by 138 members, including the speaker that was presiding, which was Honorable Joe Osewusu, including himself, that was 137. Whether they form the majority the constitution puts in place before a decision can be taken, and whether he also qualifies to vote. So these are the issues: whether he can be counted to form quorum when he's presiding, whether he can vote when he's presiding, and 3, on that note, whether the decision that was taken was binding. Now, the reason why this judgment is very, very important, and especially to you and I, and to Parliament, to the executive, and to the judiciary, to the media, and to all the world watching, is because of the slim majority. Now there is a budget that needs to be approved, and because of the numbers, in the absence of Speaker Gbagbe, now the NDC becomes 137 and the MP becomes 138, including the former MP. Now the first deputy speaker is coming from MPP, the second deputy speaker is the former MP, because the constitution says that the 2 deputy speakers can both not come from one political party. So if in the absence of Gbagbe, one person must preside who should either come from the MPP, leaving them also 137 and the NDC 137. Now, if the one presiding can be counted for quorum to take a decision, and also has the authority to vote, then anytime, so in the absence of Speaker Gbagbe, then it means that the MPP MPs could have the majority, because the one presiding could count himself and they will be 138. If he cannot count himself, then anytime they are presiding, they are 137. The constitution clearly provides that when a matter is raised and after a vote is cast and there is a tie, which means that 137, the motion should be considered lost. So that's why this decision is very, very important. Apart from the budget, there is also one very topical issue, the E-Levy. Now, the E-Levy and these processes for approval and all that will also depend on this particular judgment, because as we know now, the majority side, which is the MPP, including the former MP and independent candidate, are for the E-Levy, and the majority, which is the NDC, have also declared their stance against the E-Levy. That's why this particular judgment is very, very important. Now, what is my take on this with my little reading of the law? And let me issue a disclaimer: this analysis is done based on my little understanding of the law and the little reading of the law, which is a responsibility of every citizen. Yes, but like I told you, when it comes to matters of the interpretation of the Constitution, it is the sole duty and the mandate of the Supreme Court, because everybody can read the Constitution and interpret it based on his or her understanding. But because of that, that's why the Supreme Court is there, to be the final authority. You could express a view, and yes, of course, the Constitution even mandates all citizens to hold all arms of government accountable: the judiciary, which is the courts, the executive, which is the president, the Parliament. It is our duty to hold them accountable and to scrutinize the work that they do without showing any disrespect. Now, so where are the relevant provisions? Now, like I said, the Supreme Court, as it stands now, of Ghana, has currently, in a 7-0 unanimous decision, decided that a deputy speaker, when presiding, can be counted for quorum to be formed and can also vote. As of now, that is the authority. But let me share with you the little reading from the Constitution, and based on that, I could also express my opinion on this particular matter. Now, first of all, we must know these two things. There are 2 types of quorums the Constitution talks about when it comes to Parliament, which is Article 102. It talks about quorum to start discussions or to start business in Parliament. It has got nothing to do with decision making or voting. And with that one, when you read Article 102, it states clearly that there should be 1/3. There should be 1/3 of the members of Parliament present and voting. Let me read for you, please. Let me read. Article 102, please. It states, quorum in Parliament. A quorum of Parliament, apart from the person presiding, shall be 1/3 of all members of Parliament. You could see clearly here that in this particular provision, the framers of the Constitution stated clearly that in forming the quorum to begin business is 1/3 of members of Parliament, apart from the person presiding, Article 102. Now, let's also read Article 101. Who is the person who, if we say someone is presiding, who is he? Article 101 says, presiding in Parliament, the Speaker shall preside in Parliament at all sitting, and in his absence, a deputy speaker shall preside. So it could either be a speaker, and in the absence of the speaker, the deputy speaker must preside. So that is the first quorum to begin business. Currently, members of Parliament are 275. 1/3 should be about 92, thereabout. Good. But that is not the matter for contention now. The matter for contention is the second quorum to make decision and to vote on a matter. With the greatest of respect, if you can go with me to Article 104, it states clearly, voting in Parliament. Now, it says that except as otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting with at least half of all members of Parliament present. Now, you could clearly see something here, what the framers of the Constitution are saying here. Now remember, this is not the only Constitution Ghana has had or has had. Please pardon that. Now, Ghana has tried where a speaker can either be a member, must be a member of Parliament, and Parliament has also tried where a deputy speaker must be a member of Parliament. Ghana has also tried where a speaker should not be a member of Parliament. So in the issue of Joe Ajaho, Honorable, when he was a member of Parliament and he was supposed to be a deputy speaker, he was supposed to relinquish his seat. There was a by-election to replace him. Now, if you read Article 104 again, let me read again. Except as otherwise provided in this Constitution, matters in Parliament shall be determined by the vote of majority of members present and voting. So if you look at this provision, it tells you that there are members of Parliament that can be present but not voting because they may have a limitation to vote. Please look at this one. It says that majority of members, it says that determined by votes of the majority of members present and voting. So it means that there can be members of Parliament present in Parliament but cannot or may not be voting because of one or two reasons. Now, somebody may ask a good question. Why will a member of Parliament be in Parliament and may not be voting? Why will the Constitution give this restriction? Just after Article 104, Clause 1, just beneath that one is the Clause 2. Just under that one, it clarifies the provision above clearly. Now, 2 says that the Speaker shall have neither an original nor casting vote. Now, the first place is that a matter in Parliament shall be determined by majority of members of Parliament present and voting. It means that there can be members of Parliament in Parliament who are present but not voting. It says that it shall be determined by a majority of members of Parliament present and voting. Now the question is, can a member of Parliament be in Parliament and be present and not voting? Yes. And Clause 2 of Article 104 explains why a member of Parliament can be present in Parliament and not vote. It says that the Speaker shall neither have an original vote or a casting vote. And we also read in Article 101 that Parliament shall be presided by the Speaker or, in the absence of the Speaker, a deputy Speaker. So it tells you that an MP forming, an MP presiding as a Speaker loses his voting right. Clearly, it states clearly, a decision or all matters of Parliament shall be determined by a vote of the majority of members present and voting, with at least half of all members of Parliament present. Good. Now, 2 goes on to say that the Speaker shall have neither an original nor casting vote. Now, the reason why I'm saying that Article 104 specifically placed the limitation on whoever is presiding as the speaker, which could be an MP, and is saying that if that's the case, the MP cannot vote. It's clear. Now, let's read another provision. Let's read Article 103, Clause 4. It says that every member of parliament shall be a member of at least one of the standing committees. This one clearly says every member of parliament, whether you're a deputy speaker or whatever, every member of parliament. But when you come to Article 104, it says that matters shall be determined by a majority of members of parliament present and voting. So it clearly states that the framers of the constitution were clear in their mind that there could be members of parliament present but not voting. And when you read the sub-clause 2, clause 2, it clearly states who can be present and not voting. It says anyone presiding. It says that the speaker, which also means anyone presiding as the speaker, shall neither have an original or a casting vote. Now, people will argue that this phrase is not for the deputy speaker, but it's for the speaker. It's not true, because first of all, if the speaker is not a member of parliament, he has even lost his vote in the first place. In the first place. So this provision cannot just be for the speaker, but also for anyone. When you look at Article 11 of the Constitution, it also clearly states that the laws of Ghana shall be first the Constitution, that is supreme above all. Then the next ones are acts of parliament, legislations. Then you look at let me quickly read it. Article 11, it says that the laws of Ghana shall comprise the Constitution, enactment made by Parliament, those are the various acts, rules, regulations made by persons or authorities under the powers conferred by this Constitution. Then the fourth one is existing laws, and the last one is common law. So all these laws must not contradict the Constitution. And let's quickly look at the standing orders of Parliament, which emanated from the Constitution. So let's look at that is Article 9. Let me quickly read for you. I will indulge with your indulgence, and some few seconds I will read, and why I think the provisions in the standing orders of Parliament are not in contradiction with the provisions of the Constitution. To be more specific, the standing order 108 that talks about voting in Parliament, and you can see that it has an article reference from the Constitution, Article 104 from the Constitution. So let me quickly read that provision 108. It says that 1. No question for decision in the House shall be proposed for determination unless there are present in the House not less than one half of all members of the House, and except otherwise provided in the Constitution. The question proposed shall be determined by the majority of votes of members present and voting. So you could see that the standing orders of Parliament is also clearly stating here that it shall be determined by members of Parliament present and voting. You could have just said members of Parliament present, but it says that and voting, just like what the Constitution says. Now let's continue. It also clarifies who are members of Parliament voting, present and voting. It says that the speaker shall neither have an original nor a casting vote. An original vote means that before voting from the beginning you can partake. Casting vote means that when there is a tie, you have a final vote to decide where the matter goes. So it says that shall neither have an original nor casting vote, and upon any question before the House, the votes are equally divided. The motion shall be taken to be lost. Now, look at what the provisions of Parliament does. It goes ahead to be more specific to say that a deputy speaker or any other member presiding shall not retain his original vote whilst presiding. So, like I said, usually the Constitution is a summary of laws that governs everything that happens in Ghana. It cannot break down issues one by one. So what it does is that the Constitution sets the tone, then the various acts bring specification. And I'm glad at what the article, and this one was not done by anybody today, it was done in 1994, just after the Constitution, and they get the inspiration for this from the Constitution. And I said, after we've practiced different types of constitutions and all that, they clearly state that it shall be a matter brought before the House, shall be decided by majority of members of Parliament present and voting. That's simple of that. And Like I said, a member of parliament can be present but not voting because of a particular role he's playing. And the standing orders of parliament clearly states, and like the provision in standing order subsection 2 states clearly that a deputy speaker shall neither have an original or a casting vote, which is also clearly in the constitution, article 104 surplus 2. And it's further specified and say that a deputy speaker or any member, when presiding, shall not retain his original vote. So we understand an MP has a vote to represent his people, but I'm sure one of the basic principles of law is equity, fairness, and that's why the source of our constitution is from the common law, from the British system. If you think about it, whether somebody presiding, who is supposed to be the referee, can take a decision, and the question I ask myself with the greatest of respect, humbly, is if we are saying that the deputy speaker can be counted and can also vote when he's presiding, during voting, when it is his turn to vote, what happens? He will leave the seat as a speaker and go and vote. And the time he's voting, who will be the speaker and who is presiding? Because at every point in time, there must be a speaker. And when there is no speaker, business of parliament cannot continue. When there is no speaker, even for a second, sitting in the chair, presiding as a speaker. So if the deputy speaker can go and cast his vote, the question now that I will leave to the student of law and those who know the law better is that at the time that the deputy speaker rises from his seat when he's presiding to go and vote as an MP, at that particular time, who will be the speaker? And who will even be counting him? And who will be counting his votes? Yeah, so that is it. This is my take on the matter. But the Supreme Court has decided, like I said, as it stands now, they have the authority. But this is my take on this matter. This is my take on this matter. And I wish anyone who took the matter to court should seek for a review, and another panel will be constituted, and let's see the outcome of it. But as it stands in our day, the Supreme Court has ruled, and it stands that the deputy speaker presiding can be counted to form quorum as majority for decision making and can also vote. I clearly disagree based on my little understanding in the reading of law. Thank you very much. Once again, this is your good brother Justice MSC. Thanks. If you like the video, you could like. If you dislike, you could dislike. If you agree with us, leave a comment. If you disagree with us, say feel free. That is democracy. That's the beauty of democracy, freedom of speech. Feel free to disagree with us, write what you think. Then the most important thing is to subscribe. Subscribe, so that when there are other issues and we have to comment about it, you can get it. What we do is that when there's an issue, we take time to listen to all the issues, the facts, then we look at other opinions that has been expressed, then based on our little research, we also express an independent, objective opinion on the matter. So subscribe is very, very important. Subscribe. Thank you very much. You can share, keep sharing. Let's protect Ghana's democracy. Let's be one as a people. Thank you very much. Love you all. Bye-bye.